Thank you very much, folks. You may be seated. Okay, good afternoon, ladies and gentlemen. My name is Judge William Altfield. It is my honor to be serving you as your county court judge. We are here on the matter of Justin Drew Bieber, State of Florida versus Justin Drew Bieber, and in addition, we also have the members of the media, counsel for the members of the media. If you can all announce your names for the record.
One President of the State.
Good afternoon, Your Honor. Roy Black, Mark Shapiro, and Howard Shrebnick on behalf of Mr. Bieber.
Thank you.
Good afternoon, Your Honor. Scott Ponce on behalf of the Miami Herald and CBS television stations.
Thank you.
And Your Honor, I'm Deanna Schulman on behalf of the Associated Press, CNN, Orlando Sentinel Communications Company, Scripps Media Inc., and the Sun Sentinel Communications Company.
Okay, thank you. Okay, we are here on the matter. There was a motion for injunctive relief, a motion for a protective order to restrict the disclosure of videos taken of Justin Drew Bieber while he was housed in the Miami Beach Police Department jail house, for lack of a better term, and I've had received responses from the state, and I've also received as interveners responses from the media with regards to this issue. The court did issue an order for temporary injunctive relief on February 24th, 2014. And it is my understanding that that order has been complied with, and several of the videos have been released. So now we are at the issue where the court needs to make a determination as to whether or not the recordings will be released. So the question is to see or not to see, whether the media and the public will have the ability to have unfettered access to these jailhouse recordings of Justin Drew Bieber, or, as the defense has requested, to prevent the disclosure of these recordings. There are several things that the court wants to put on the record first, to put everything into context. Specifically, as it relates to this case, the defendant, Justin Drew Bieber, is a well-known, famous music entertainer who was arrested on January 23rd, 2014 for the offenses of driving under the influence, resisting without violence, and driving with an expired license. He was taken to the Miami Beach Police Department for processing, to not only processing and booking, but also for a breath and or urine test. And while in custody at the Miami Beach Police Department, the defendant was caught in recorded images from cameras at various angles, doing many things such as walking, talking, standing, sitting, conversing with others, and as well urinating. And the court does find that the defendants, these recordings that were maintained by the Miami Beach Police Department are public records. When we say they are public records, we are defining them as those records that the public should have the right to see. They are governmental records that have the intent of perpetuating or formalizing knowledge in connection with the transaction of official agency business. So that is the first finding that the court makes. While it may have been in dispute that they were originally public records, the court also finds that they clearly became public records when the defendant invoked discovery, and discovery was provided to the defense. Thereby, these are, again, under Rule 3.220, considered as public records. The court also finds that the defendant does have standing. It was disputed by the counsel for the media that the defendant did not have standing for this protective order, but the court, through Rule 3.22M, which provides that upon request of any person, the court may permit any showing of cause for denial or regulation of disclosures or any portion of such showing to be made in camera. In addition, Rule 3.22L allows the court to restrict disclosure to protect a witness from harassment, unnecessary inconvenience, or invasion of privacy. So now we have public records that have been maintained by a custodian, and under our Public Records Act, we must determine whether or not these are fully disclosed or whether or not there is an exemption. Our Florida Constitution gives a broad scope of the right to privacy, and in fact, that is something that the court needs to consider in making its determination. So, is there an exemption preventing the disclosure of these records? The court does find that governmental records are presumptively open and that the Public Records Act is to be construed liberally in favor of access, unless the information fits under a legislatively created exemption. There is no statutory exemption to these images. The court does find, however, that portions of the public record at issue clearly have no relevance to the need for disclosure, and as such, pursuant to the guidance of Section 119.07, the court does believe that there should be some type of restriction of these records that are depicting images that the court finds to be irrelevant to the public's right to disclosure, and in balancing the defendant's right to privacy with the public's right to know, the court will be restricting disclosure. What will be restricted? Well, the court, in making its determination, is balancing the interests. We have an interest, certainly everyone's interest, to make sure that the public has the right to know. In this instance, we have a very well-known music entertainer who the public finds in the media in all forms, written, video, audio, and certainly the public has a widespread interest in his activities. So certainly when a public figure such as Mr. Bieber is arrested, it is expected that the public would want to know about the events that have taken place, that are taking place, and that will take place. But it is important to note that this case is not about the First Amendment rights of the media to publish material already legitimately in your possession. It is a case that deals with the obligations of a government official having custody of public records to disclose those records when the disclosure would impinge on recognized privacy interests of an individual who is the subject of those records. It is the public's right to know rather than the media's right to publish that is at issue here. The court looked to the case Post-Newsweek Stations Florida Incorporated versus Doe, which was the Kathy Willits case, for guidance. The court looked to determine what language they utilized to decide what shall be restricted from disclosure and what shall not be restricted from disclosure. And what the court did withhold was information that would be of intimate, potentially embarrassing information. And I stress potentially embarrassing information, because it was stated or articulated by counsel for the media that the defendant did not provide any evidence of injury. Well, the court does find that clearly if the disclosure of the defendant's genitalia or disclosure of the defendant urinating took place, that clearly that is potentially embarrassing. and this defendant does have a right to privacy to prevent that from taking place. So the court has an obligation to ensure not only that this defendant has a right to a fair trial, but also the public's rights to access to these proceedings. What is relevant is the defendant while he is in the jailhouse. The court finds that this is a criminal proceeding, and the evidence of the criminal proceeding is something that the media and the public have the right to know, to analyze, to inspect, to determine not only will the defendant receive a fair trial, but will the state receive a fair trial. So if the defendant is depicted in these images, walking, talking, standing, communicating, that is something that the public will be able to say, okay, this is the evidence, this is part of the evidence that the state may be relying upon. And they will be able to gauge for themselves the strength of the state's case or the weakness of the state's case. And the court does find that all of those images are relevant. What the court does not find to be relevant are any images that depict the defendant either urinating or the defendant's genitalia being exposed. There was some language that the defense had written in their response that I found very telling. And it said, inmates in jails, prisons, or mental institutions retain certain fundamental rights of privacy. They are not like animals in a zoo to be filmed and photographed at will by the public or by media reporters. This court believes that while this defendant, as an inmate in a jail setting, may have a lesser expectation of privacy that he would have enjoyed outside of a jail setting, he has not lost his expectation of dignity. And that's what's the most important here. That this defendant, while he is a public figure, still maintains that expectation of privacy and still has an expectation of dignity. Counsel for the media said that the defendant may have relinquished his expectation of privacy because he, on his own accord, had somebody videotaping him urinating in a bucket, and thereby he now has relinquished that expectation of privacy. The court acknowledges that we were all 19 at one time or another, some long ago than others, but we do stupid things in our lives. We do foolish things in our lives. And this defendant, that his expectation of privacy should stay with him at all chapters in his life and even beyond when he leaves this earth. And I'm citing the Earnhardt case, where Mr. Earnhardt's autopsy photos were declared to be restricted from disclosure, and the legislature found it important. The right to privacy is paramount, and Mr. Bieber's right to privacy is paramount. Therefore, the court finds that there exists a right to privacy as it relates to the exposure and dissemination of the defendant's genitalia. As such, any images that depict or appear to depict the defendant's genitalia shall be restricted from disclosure. Pursuant to the Barron analysis, the court finds that there exists a presumption of openness and access to the court records, specifically the jail surveillance recordings. However, the defendant has met his burden by arguing that a substantial injury may be caused by the disclosure and dissemination of the defendant's genitalia to the public and media. The court further believes that the proper method of closure is to redact the image wherein genitalia is observed, and further finds that there is no other reasonable alternative, and that the redaction as stated above is the least restrictive means of closure available. Further, had the video recordings depicted any images of the act of urinating, which they do not, this court would have additionally found a right to privacy existed in those images and would have ordered those images to have been redacted from the media and the public. Therefore, the State Attorney's Office shall forthwith provide and make available to this court an audiovisual technician who will receive instructions on the redaction of the above referenced images that depict or appear to depict the genitalia of the defendant. And the court is also including in its order the male depicted in the recordings. This male is presumed to be Khalil Amir Sharif. Now, although Mr. Sharif has not filed a motion for injunctive relief, this court, as the gatekeeper, is tasked with the responsibility to ensure that all defendants receive a fair trial, as well as are protected. Their constitutional rights are protected, and therefore all images of Mr. Sharif depicting his genitalia and or the act of urinating will also be included in this order. Specifically, the segments that the court has found to be objectionable and subject to redaction are DVD 2 of 9, segment 201-40123-045734-040010. In addition, the court includes DVD 4 of 9, segment 2014-012-3-065-734-04000100. So therefore, those two segments will be the subject of this order redacting those images. Otherwise, any orders that are not of those two segments shall be released to the public. Is there anything further from either the defense, the state, or the media, for the record?
No, Your Honor.
Okay.
Your Honor, just one
Yes, ma'am.
point of clarification on your use of the term redact with the two clips that you mentioned. By redact, do you mean that the public will not be entitled to those clips at all?
No.
Or by redact, do you mean technological measures will be put in place to protect those areas?
I don't want to use the term bar or some type of technological technique will be used to shade or blacken out that area which would depict the objectionable images.
Okay. And then those clips, those two clips will become otherwise available?
Correct.
And the rest of the ones Your Honor reviewed in camera, will they become immediately
Correct.
available?
Yes.
Thank you.
Okay. Anything further from the states?
Judge, we have one moment.
Yes, yes, sir. Wait a minute, not yet, not yet.
Your Honor, the reason I asked for a little clarification, and
Sure.
perhaps we should get to the state, since they're going to be submitting it to the court, although I think the court may have already seen it. There are 5 clips involved, and I know the court referenced 2 of them, and quite frankly, off the top of our heads, those numbers are far too confusing to figure out.
It's all in my order, which you will be getting
Okay,
in just about
perfect.
5 minutes.
All right. Thank you,
Okay.
Your Honor.
All right, thank you.
Judge, just a couple of things. I think there were 5 pieces that we had already, I guess we had
5 segments,
5
correct.
segments. Out of those 5, 2 of them you were saying still remain to be redacted.
Correct.
The other 3 can. Is it all right if we, instead of having our technician come over from our building, can we have our technician do, then we can bring you the copy of what we believe is complying with your order before we actually do anything? Or do you really want our
better yet, what I
technician to
would
come
like,
here?
no, because I want to make sure that, I don't want to go piecemeal. I want to make sure, have this person come, I will show this person where I believe it to be objectionable and block it out.
Okay.
And therefore, then he will go ahead, do his work, and then I will review it to make sure that it comports with my order, and then we can go ahead and release it.
Okay, well, we'll let our public records people know that.
Okay. All right.
Does Your Honor set forth a time frame for that to occur?
I'm available today.
Well, I don't know.
No, I know, I understand it. Look, but you know what? I want somebody here by tomorrow, at the latest tomorrow.
Well, Your Honor,
understand that-
I think that question's a little unfair, considering the parties have been very expeditious in doing this. In fact, within a day or two, we got to the court which ones we were objecting to and which ones we weren't. So nobody is dragging their feet here in order to deny them immediate access. So I think the parties are working reasonably for doing this, and I think you ought to rely upon that.
No, I am, and quite frankly, I mean, I'm only talking about having a technician coming over to my chambers, going
Right.
over it. Certainly, I don't think it takes that long to.
I just don't know as Your Honor may recall from your time in our office, we don't have that. We have 2 people in our litigation support, and I don't know what their schedule is for today and what they may be working on for some trials. So that's the only thing. So I can't give you that answer until they go back there and see,
Okay.
are you available? That's all. So we'll get there, somebody here as soon as possible. Call your chambers to let you know that.
I will be available whenever you need.
Okay.
Let's just leave it at that. Okay.
Okay, thank you.
Now, there are anything further on this issue?
No, sir.
Okay. We do have a couple of housekeeping matters with respect to the case. we are currently without a trial date.
Yes,
Now.
sir.
Go ahead.
Can I make a suggestion that Your Honor set this over for a week to set it down, to set a trial? There are some procedural things we'd like to talk to the state about before we actually set down a trial date. That's possible.
Okay, let me hear from the
My
state.
only concern with that is we've already postponed the sounding date, and speedy trial issue is still, out there in the open. The more we delay this, the less time the state has. At some, at some point.
We've certainly asked for these things, so I think that's a waiver of the state of the speedy trial.
You are on the record stating
Yes.
that you are waiving your
We are-
client's speedy trial rights.
We are waiving our client's speedy trial rights. We're much more interested in the substance of the matter. I don't think that the state is going to let those days go by. So,
Okay.
yeah.
There's no objection.
All right, with that representation. So you want to
See
give
how
us a week,
confident I am in you? Yes.
a week for status?
Yes.
All right. Special set. How does the 11th look? A week from today.
That's fine, Your
It's
Honor.
fine with the state.
Okay. We'll make it. Let's do it a little later. Avoid the craziness of the morning calendar. How about 11?
Perfect.
Okay. Now, there was another issue. The state and counsel for the defendant, Mr. Sharif, had, during the last proceeding, said that there were some discussions about not consolidating, but joining these cases for trial at the same date. So I want to see if, in fact, that can be resolved prior to that date.
That's an issue that we have not discussed with Mr. Black. However, the state would definitely be interested in keeping the dates either as close as possible together or on the same day.
Okay. As I mentioned, speak to counsel, have everybody on board, and then you can approach me with what you're considering.
Well, I think we can report back to you then.
Yeah,
Next
exactly.
week on
That's
that.
fine.
All right.
Okay. What do we need? Yeah, we're gonna reset the misdemeanor case as well on March 11th at 11 a.m. And there are copies of the order. I've given it to the clerk. It will be stamped and filed as of today's date. I want to thank everyone. Having professional, well-seasoned lawyers in front of me makes my job so much easier. I really appreciate the time that everyone has put into this issue. Thank you very, very much. Okay.
Your Honor, having said that, I just want the record to note in 44 years, I don't think a county court judge has ever entered such an extensive order. So we need to thank you for taking the time of doing that.
Thank you. Thank you, sir. Okay. All right, so if there are no further business, court will be in recess. Take care.
Thank you, Judge.
Bye-bye.
Certainly. Thank you. Well, it's true.